You do realise that without my permission as a police officer, you cannot use that video, and I can confiscate that as well if I need to. All right, then. At this moment in time, you're staying under Section 23 of the Terrorist Act, okay?
23?
Section 43 of the Terrorist
Welcome to Ringvex USA, where police power collides with public accountability. This episode is powered by Free Time's Audit. So make sure you follow the link below, subscribe to his channel, and give him the credit he's earned. In this video, Auditor FDA is calmly filming the gates of a police station from a public pavement when, without warning, 3 officers approach and quickly surround him. Taking the lead is a visibly flustered and unprepared officer who seems completely unequipped for a calm, lawful conversation. Instead of assessing the situation, he panics, leans on bluster, and rushes headfirst into what becomes an unlawful detention, apparently believing his badge can substitute for actual legal authority. But as events unfold, the ending tells a very different story.
How do you know that's what I'm doing?
Because you got your phone out, pointing your camera towards personal cars.
Taking pictures of the fence.
What?
I'm taking pictures of the fence.
Why are you doing it?
What's it got to do with you? Shall I come round to the side?
Act. Well,
Alright.
what are you doing?
Taking pictures
Of
the fence.
the fence. Why?
I like fences.
Like fences?
I went to the reception, she said it's fine.
Right, it's not fine, is it really?
Is it not fine?
No. Current threat levels at the moment, isn't it, for the police, and you're filming private cars?
Can you draw a step back a bit?
No, not at all. What's your name, buddy?
I'm not telling you my name.
Not telling his name? Right.
Don't need to. Well, you just need to grow up with it. Don't you?
Really?
Yeah. Because all you're doing is just trying to antagonise people.
I'm not trying to antagonise anyone.
Yeah.
No, I'm not.
Yes, you are. You're still filming personal people's private cars.
I'm not filming the cars.
You sat there. I've just watched your screen. You're videoing.
I know I'm videoing,
Exactly.
but I'm taking pictures of the fence.
Yeah.
I went to reception. She
PC Morris opens with a rushed and familiar claim, "You cannot film a police station because of current threat levels." Yet that statement ignores a crucial fact. There has not been a single successful terrorist attack on a UK police station in over a decade. Moreover, among all disrupted plots since 2010, none involved someone openly filming from a public pavement. Official guidance from a Metropolitan Police, the Home Office, and the Metropolitan Police and Crime Commissioner clearly states that photographing police buildings is lawful and, on its own, does not create suspicion. That position is not vague. It is formally recognized. Consider the bigger picture. Millions pass police stations every year. Tourists capture landmarks. Vloggers record daily life. Passengers film from buses and taxis. Yet time and again, auditors are singled out and treated as if they represent a national security threat. The inconsistency speaks volumes.
Personal car.
I'm not taking pictures of cars.
When the threat level is very high.
Even if I was taking pictures of cars, is it against the law?
You can film. I'm just asking you why with the current threat level. What do you do for a living?
It's my own business.
You're a child.
I'm a child.
You act like an adult.
Do you need retraining now to deal with the public?
No.
I think you do.
Not really.
So you, mate?
What?
So you?
Nothing.
You got a good photo there?
Video, mate, video.
Video. You do realise that without my permission as a police officer, you cannot use that video, and I can confiscate that as well if I need to.
I don't think so.
I do.
What law is that?
On the pace that I'm going to find out at this moment in time.
Alright, am I being detained?
At this moment in time, you are.
For what?
Well, we're going to get the code at this moment in time, and I'm going to search it under that.
Alright, yeah.
And then you'll have to provide your details as well.
No, I don't. No, I don't.
When you're saying you do.
PC Morris demonstrates a striking misunderstanding of the powers he claims to wield. He confidently insists that FDA cannot use his own footage without permission and suggests he can confiscate it at will. That is not law enforcement. It is fiction. No UK law grants a constable ownership over footage recorded in public. A camera cannot be seized unless it contains evidence of an actual offense. Then, escalating further, Morris closes in and suddenly declares FTA detained. When asked the obvious question, detained under what authority, he responds, "I'm going to get a code." That answer captures the entire issue. By that stage, FTA's liberty has already been restricted without lawful grounds, and Morris is scrambling to justify it after the fact. This is assumption-driven policing, where authority is improvised in real time instead of rooted in law.
Are you recording? Yeah. You should inform me, shouldn't you?
It's there.
It's there. I know you got a camera, but I don't know it's on, do I? Until you inform me.
All right, then. At this moment in time, you're staying under Section 23 of the Terrorist Act, okay?
23?
Section 43 of the Terrorist Act.
43, right, yeah.
43 of the Terrorist Act. So basically, you're ballied up at this moment in time and you're taking personal videos of that, okay? So I'm going to ask you to remove that at this moment and give me your personal details.
Right, under Section 43, I don't have to give my details.
Well, you do at this moment in time. If you details provide out under this search at this moment in time, I'll just arrest you, mate.
For what?
For this moment in time, for a possible terrorist act.
So you think I'm a terrorist? I'm overt. I'm not covert.
Okay.
Have you read the memo?
What memo?
On people filming around police stations.
I have.
Yeah?
Bit suspicious though, isn't it, pal?
No, it's not suspicious, because I've told you exactly what I'm doing.
You know, filming fences.
Yeah.
Why?
I like fences.
Why do you like fences?
Because that's what I'm into. That's what I do in my free time.
Where's your best fence then? That you've got?
Um,
Show me other videos then of your best fences.
I like police fences.
Like police fences?
Yeah, yeah.
Right, so that's a bit suspicious.
Eventually, Morris receives a legal reference over the radio, only to misapply it dramatically. He first blurts out Section 23, which has nothing to do with terrorism or detention powers. When pressed, he pivots to Section 43 of the Terrorism Act, exposing that he never had proper grounds to begin with. Section 43 demands specific and reasonable suspicion of involvement in terrorism. It does not apply to someone holding a camera, nor can it be justified by vague threat levels or secondhand guidance from a colleague's radio. The situation worsens when Morris demands FTA's personal details and threatens arrest for refusal. This is no minor error. It is the invention of powers that do not exist. While Section 43 allows a search, it does not compel identification. That overreach turns a flawed encounter into a clear breach of legal authority.
Before I search then, you got anything that's going to harm you or me or any of my colleagues?
No.
Okay, do you want to take your hands out of your pockets then for us?
Yep.
Make sure you get the good side.
Turn round.
Why's that?
Get your good side.
That's good side. Reckon we got 2 phones on you?
That one's for phoning, this one's for taking pictures.
Well, you said he was videoing, not taking pictures.
Well, you can take stills of the videos, can't I?
Ah, I see. So you tried to correct me before, but you were wrong yourself, wasn't you?
I'm not wrong, am I?
Well, you was, wasn't you? Got a Jaguar key. You know what they say about people who drive Jaguars, don't you?
What's that?
Drive Jaguars. Right, well, as long as between your legs do not kick out, it'll be your... Right. I just think you should leave.
Can I put my stuff back in my pocket?
It's your stuff.
Yep.
Right, you got another defence now. I think you should move.
When the search reveals nothing, the encounter should have ended. The entire purpose of a Section 43 search is to confirm or dispel suspicion. With nothing found, the officer's role is complete and the situation should naturally de-escalate. Instead, Morris remains visibly tense, continuing to treat FTA as if he poses a threat. When he says, "I think you should leave," you've got enough of the fence. It is not about safety. It reflects discomfort and bruised pride. He struggles to accept that FTA has every right to stand there and film. Even after confirming there's nothing unlawful, Morris pressures him to move, managing his own frustration rather than following procedure. A competent officer would have simply stated, "Search complete. You are free to go," and allowed the matter to end without needless escalation.
What on there?
Good. Bye-bye.
Look at this fence, this is interesting. Just going to get all the fences as I walk down, is that alright?
Switch it off, mate. Don't need to.
You can't tell me to switch off.
Oh, you might have done. That's it.
And you never got me details, did you? Because you can't get me details. Under Section 43, you can't. Off you pop.
I'm just here with an update from the solicitors who've basically confirmed that they've received a response from the defendant, which is the PC Morris, PC 16660 from Longside Police Station. They have rejected the Part 36 offer, and their stance on liability is not changed. And the only way to progress is to issue court proceedings.
The letter from FDA's solicitors reveals more than it first appears. When legal representatives note that the defendant has rejected a Part 36 offer, It signals refusal to settle and a willingness to face mounting costs. Part 36 offers exist to resolve disputes efficiently and minimize expense for both sides. When a police force declines such an offer, especially in a case involving an unlawful stop, detention, and search, it often reflects posturing rather than confidence. While the rejection may have been intended to project strength, it achieved the opposite. It effectively told FDA's legal team that pursuing the case to full conclusion was justified and necessary.